So it's 2 o'clock and the meeting is now reconvened with the evidence given by Gary Primrose on behalf of Krishnamurti Foundation Trust.
Thank you, Chair. I was just going to ask Mr. Primrose a number of supplementary questions. The first is this: we already know, because they've started selling the tickets, that tickets for this festival are on sale. You've included in your statement at page 61 examples of a third party that's selling them. It's not the children who are selling them. It's a special company, list.co.uk, a paid promoter who's running them. Is that right?
Yes, I think. Tom, have you got any more information about that?
You come forward.
Yeah.
Oh, you have to come to the microphone.
Thank you. Yeah, just to add to that, we unfortunately found we got an alert from our Google Suite. As a school, we have a Google Suite, and it gives us an alert when third parties are using our name. And we unfortunately received an alert from this software saying that Brockwood Festival was selling tickets through Brockwood Park School. And we were quite shocked by this. It turns out it's a third-party promoter who have registered the address of the festival as Brockwood Park School. I don't know why, but obviously for us this is a major concern, especially when it comes to donors, visitors, our reputation, that we're somehow seem to now be promoting and running a festival ourselves, which is the suggestion that's out there. So.
You've included also in your exhibits an example of what festival goers are encouraged to do. This is page 51. It's called Exhibit 3, social media posts associated with the current application.
If I may, Mr. Rankin, you keep referring to page 61. The main agenda, that's a letter from Michael Curtis. Is this on a supplementary? I'm afraid.
You're quite right. It's my fault. It'll be supplementary agenda 3.
Thank you.
The same one with Mr. Primrose's statement in it.
It's not number 3. We're just getting the for the members, Mr. Rankin, bear with us.
I think it's the that one. I think it's that
That
one.
one.
No, it goes in.
Yeah.
On page 61, I enclosed social media.
Okay. Members, it's the supplementary agenda dated 8th of April 2024. It's where the noise assessment or impact assessment from Sustainable Acoustics, we've just gone through. It's continuing after the noise report. So page 61 of that one, members.
51.
51. Apologies.
Mr. Primrose's statement is at 61, but some exhibits are exhibited prior to that.
Members, you with us? So 51 onwards, you're being referred to.
Yes.
Thank you. Thank you, Ms. Wright.
Exhibit 3, below are a range of posts from the festival organisers' social media feeds. These concerned you, although the writing is small. This is the substance of the writing. Bullet point. Here the organisers are encouraging people to bring some cans for the campsite if you fancy a tipple when the bar stops serving. Clearly encouraging drinking after 2 AM is questionable if they're hoping to reduce noise in the early hours. We also have concerns about campers bringing portable speakers and continuing the party after the official stages have finished. So we know that they're asking for licensable activity until 2. That's for the dancing, that's for the late night refreshment, and that's for the alcohol. After 2, there is the campsite. And what is being proposed, certainly the encouragement appears to be this in the social media post, is that people are encouraged to bring alcohol on site. We don't know what their search procedures are. We don't know what their alcohol procedures are for seizing alcohol for people bringing it into the campsite. But just assume that I've appeared with my camper van. It's brimful with alcohol. I park it in the car park. The music finishes at 2 o'clock and the dancing's finished at 2 o'clock. And I go and start my after party at the campsite. Now, is that something that you experienced over previous years or not?
I can't say directly that we have, but it's certainly a concern. Yeah, I mean, we've met a number of times, Alistair and Patrick and myself with Rob as well, to walking the site, and we've been in communication over this. And one of the things that we've talked about is, on one hand, there's a clear good intention from Patrick and Alistair to kind of do the right thing, but at the same time, there's an enormous pressure to return a profit on the festival, to recoup their money, and to then make some money for the farm, as they've made clear. The difficulty of that, of course, these are sort of opposing forces. So for us, having a look at the social media feeds as a sense of what's actually going on, you know, rather than what they say. And we've been very clear talking to the guys that we have to respond to the application actually lodged, not what they're saying. So yeah, I mean, clearly, you know, having had friends and myself gone to festivals in my youth, you know, this is a factor of festivals. And at the moment, based on whichever plan they want to submit, the current plan under review is that campsite is right next to our grove, which we talked of earlier.
Let me just identify that on a map. If we go to page 57 of the same supplementary agenda, this is an extract, yet another plan from the traffic management plan.
Mm-hmm. Yeah.
There's an area to the bottom left, which I'm going to point to, which is a green area. Is that the Grove?
That's right. Yes, Chair. You'll see that in the bottom left-hand corner of the what's called Figure 4.1, site layout and sound system locations. That little patch, that little green patch in the bottom left-hand corner above the scale bar, that is our grove that Krishnamurti wrote so eloquently about. And the people come from miles around internationally. They come to see this, spend time in this very special place. And you'll see it's right next to the proposed edge of the site plan with camping, a stone's throw, less than a stone's throw beyond. So.
Well, Mr. Payne will say, well, if I'd been permitted to put my plan in, you will have seen that the camping has moved over onto the other side.
Yeah.
Does that allay any of your concerns about the Grove?
No, unfortunately not. No, not with the number of people coming on site and what we've seen in the past, of people wandering off the festival site and up the drive. Unless we sort of plan it in and have a sort of 24-hour sort of management where we're on duty, kind of guiding festival goers off site. I don't believe that's our.
Yes, that shouldn't be your remit.
No, it's not our remit.
And let's say that you do close the centre during the course of the event, if it's allowed its license. You won't have any guests appearing, but you still have how many members of staff present on site?
Yeah, there's about 17 flats within the main school building and an additional 4 down in the centre, the Krishnamurti Centre, which is 100 metres beyond. So it's around 21 individual flats, some of which have more than one resident. So they live there all year round.
They're the full-time residents.
Full-time residents. Yeah.
And they're the ones that are going to be immediately affected in the same way that you were in 2021 and 2022.
As well as in the main house, there are At least 4 flats that hold staff members in the main house.
And then just for completeness, Mr. Primrose, you've, rather than repeat everything, you've added on to the back of your statement from page 62 onwards, a summary of the evidence of just some of the people that have made representations who are sitting behind me.
Yes, that's right.
All right. That was all I was going to ask.
Thank you very much, Mr. Now, Mr. Primrose, if you just stay there a moment.
Yes?
Do you, and if you have
No, I don't.
questions for Mr. Primrose? Do you have questions for Mr. Primrose? Any other parties in the gallery have questions for Mr. Primrose? No, you are excused, Mr. Primrose. Thank you very much.
Thank you very much. Thank you. Now, I was speaking to Mr. Lucas just before we resumed the session, and he has told me that I do not have a closing speech. You'll be relieved here. So what I'm proposing to do then is just to encapsulate the sum total of my arguments. I know that you will have read, we have a licensing consultant who was a former head of Clubs and Vice, and he's called Mr. Bamber, and his statement is in the same supplementary agenda that we've just been looking at page 27 onwards. And he makes a number of criticisms. Just make sure you've got that turned up. Thank you. He makes all sorts of criticisms of the way that the premises have positioned this application. By way of example, he talks about the traffic management plan, the TMP, which is a plan which was outlined for an event that was lasting for 2 days. And we know, of course, that it's an event that will last for longer than that. He also makes a number of observations about the way that effectively the applicant has sought to avoid any discussions about policies, about their search policies, their drugs policies. If we are to look at the main agenda, I'm sorry to keep hopping around, but if we're to look at the main agenda, and you'll see at page 49 onwards, is the submission from Security and Event Solutions. Now, if you look at the bottom of the page, it talks about the event management plan. And the event management plan is the applicant's answer to everything. What about this? It'll be in the event management plan. You don't have the event management plan. We haven't had any sight of the event management plan. You haven't had sight of any of those individual policies in this suite of policies, the alcohol management plan, the traffic management plan, security and steward management, noise management, you have seen. Major incident you haven't, medical provision, evacuation, counterterrorism, food safety, drugs policy, none of that have you seen. Welfare policy, lost and found child policy. That's a curious one, because what is being suggested is that there would be nobody under the age of 18 on the premises. Why they need to have a lost and found child policy is a mystery. Health and safety, fire safety, adverse weather plan. We have a pouring with rain in July, as often happens. The point is a simple one. that it's not good enough in circumstances such as these simply to say, don't worry, the safety advisory group has got it all in hand. A sensible applicant does this. They don't sell tickets before they've even got the license in their hand. And what they do is that they sit down and they put together a sheaf, a schedule of all of these policies, and they present them to you and say, these will be approved by the safety advisory group. But just by way of information, just so that you can satisfy yourselves that we really know what we're doing, this is what we plan for these premises, so that you can rigorously scrutinise an application such as this, particularly in circumstances when you have this number of objectors sitting behind me. So that is a matter of some concern to us. Also of concern to us is a suggestion in Mr. Payne's submissions received last night about the import of the paragraph 1.5 in your policy, purpose 1 and purpose 2, and the South Downs National Parks Authority. There's an extraordinary submission that Mr. Payne makes. I don't know what the page is, but it's Supplementary Agenda 5. And it'll be the page that starts paragraph 23 at the top. So it's Supplementary Agenda 4, page 7.
Chairman, members, you with us? Yep. Not that one, Chairman. Number 4.
Supplementary Agenda 4, page 7. So this is what Mr. Payne says. The matter of the location of the venue being within the South Downs Park Authority, SDNPA area is suggested as being a relevant factor in view of the content of the statement of licensing policy. This is what he says. That policy and the relevance of it to licensing proceedings appears to have been interpreted incorrectly by a number of those making representations. It has not. The relevance is, of course, primary in relation to matters relating to town and country planning and not to licensing. Now, quite where Mr. Payne derives that proposition from, I'm unclear, because it could not be clearer that the matters of Purpose 1 and Purpose 2 and the SDNPA were introduced into your policy, your statement of licensing policy, following a proper meeting to consult and to discuss and adopt. And there is no question but that Purpose 1 and Purpose 2 relate to licensing. It is in effect a fourth licensing objective because you're required, you're obligated by law, you're a relevant authority exercising your powers under Section 245, which was mentioned earlier, of the Levelling Up Act. You're required to take those matters into consideration. So for Mr. Payne to say, oh no, it's planning, not licensing, is just wrong. The policy statements made in the licensing policy are of no more weight than others made under the same heading, such as those regarding food hygiene and the general prosperity of the area. No, it's not. This is a specific duty that you are charged with and have reduced to words in your statement of licensing policy. Your statement of licensing policy is a transparent way of this committee explaining to the community at large how you will treat applications so that applicants know what's expected of them and objectors know how they will be treated and how you will deal with an application. Now, our expectation is that you will comply with your policy, Purpose 1 and Purpose 2. And if Purpose 2 is in defeat of Purpose 1, then Purpose 1 is the one that prevails. To conserve and enhance the natural beauty, wildlife and cultural heritage of the area. To promote opportunities is Purpose 2. That's what the two Morton boys are saying. They're saying, well, look, the opportunity for our friends to come and enjoy this beautiful countryside. Purpose 1 trumps that. Purpose 1 requires you to conserve and enhance the natural beauty, wildlife and cultural heritage of the area. And Mr. Payne says, well, that's nothing to do with licensing. And I say, with respect to Mr. Payne, look at section 245, look at your policy, it's perfectly clear, it's got everything to do with licensing. And then in an attempt to dismiss the question of the bats, he says, addressing the matter of the bats, of which no evidence appears to have been provided. Well, you've heard plenty of that today from Mr. Power, a biologist by training, who's actually recorded the bats in flight. You've heard evidence from Mr. Primrose about the existence of rare birds, including firecrest. You've heard evidence from somebody that has been involved in horticultural pursuits for many, many years now, to say that it will take some time for the habitat to recover after an event such as this. Now, the duty that you have is an ongoing duty. It's not just a question of ticking the box. You may have come across cases where you have had to apply the Equality Act. But essentially, the duty that you have is to seek to further. It's an active duty, it's not a passive duty. And any relevant authority must take all reasonable steps to explore how the statutory purposes of the protected landscape can be furthered. They're not furthered by granting a license to these two gentlemen in circumstances that they have outlined for the numbers of people that they wish to arrive at these premises. It follows as night follows day. The evidence of Peter Rogers, uncontested, you would have thought that the very least that the applicant would have done was bring their expert. So at least we could have had a proper debate about the acoustics. But as it is, the evidence that you have is the report, because that's all it is. It's not a noise assessment. It's not a noise impact survey. It's just it's a noise management plan without all of the important features that would have been expected in a plan such as that. They didn't even take the background readings. And when you're asked to compare the two, the man that I'm going to ask you to accept as being the expert in these matters is Mr. Rogers, who has no doubt in his mind whatsoever that if you grant a license in the terms that they seek, that there will be a severe impact on residents, both before 11 o'clock and after 11 o'clock. Please don't be tempted in a case like this to say, well, we'll just grant it to 11 o'clock and then everything will be fine. There's no question that at the levels that have been set by them, arbitrary levels just pulled out of the air without any hard empirical evidence to back it up, that if those levels are imposed as a condition, there is no question but that they will be 14 decibels over what Mr. Rogers says should be the correct level during the day, and 17 decibels over what the correct levels should be in the evening.
No, Mr. Rankin, have you finished?
No, no, absolutely not. It's good. It's important that everybody understands precisely what is going on. So, Mr. Payne seems to suggest that the raising of the question of bats is some sort of forensic ploy on our part. He says this, addressing the matter of bats, which is of which no evidence appears to have been provided. The applicant is aware of the potential for disturbance, but also that this is a matter which forms a part of another statutory regime where there are penalties available, such as the Wildlife and Countryside Act 1981. Then he concludes, it is therefore not a consideration in relation to the grant of a license. Just because something has a penal outcome in another statute doesn't prevent this matter coming before the committee. It makes absolutely no sense to say, well, that they can be prosecuted under the Wildlife and Countryside Act, therefore you can't take it into consideration under a licensing act application. Of course you can. And he says this, it's understandable in the furtherance of an ambition to have a license refused that an objector will try to raise any point that otherwise seem persuasive. It's a little bit dismissive, if I may say so. The suggestion that it's being used as some forensic ploy, some persuasive point. There are criminal sanctions for interfering with bats. Bats have stopped fuel pipelines from being laid. It's not something that is dealt with lightly. And it was raised at an early stage. And what your policy says is that they have to engage with the South Downs National Park. And Mr. Payne disingenuously says, well, they have been engaged with. Certainly they were served with notice of the application, but they haven't pursued what is your encouragement in your policy document, and that is that they actually engage with the South Downs National Park. Wouldn't it be easier for them to come before you and say, somebody raised the issue of bats, we went to the SDNPA and we said, do you want us to do a bat survey? And the SDNPA said, no, we don't need to do that. But they didn't do that. Well, what they could have done was they could have had their own bat survey done. That would have been an easy matter. These meters for gauging the song of the bat, easily obtainable. An expert could have come along, just done a little survey and said, yes, no, it will or won't impact. That's what they could have done. That the onus is on the applicant to show you that they are not going to adversely impact. The obligation is on you to follow the section 245 injunction upon you to perform in the way that you do. It's rare that one comes across an application which has been so poorly put together. Even the question of a risk assessment, section 1.6 of your statement of licensing policy, they're told to do a risk assessment. Have they done one? No, they haven't. Well, if they have, we haven't seen it. Perhaps the Safety Advisory Group has seen it. The licensing subcommittee wants to see a risk assessment in every case, and it's not an answer to say, well, don't worry, Safety Advisory Group are going to be dealing with it. The question of the restrictive covenants has been dealt with. I've said that insofar as it's relevant to this extent to show that the applicants are being played fast and loose. The dating of the new, I'm going to call it Plan B, and the removal of the area for the restrictive covenant with a plan dated the 7th of February, with a plan deposited in yesterday, it's perfectly clear that they have known about this all along and have sought to keep their heads below the parapet in the hope that the restrictive covenant issue would not come to light. But it has, and they've sought to address only one of the covenants. They have not addressed the covenant in Godwin's Copse, and they have absolutely no right to be running a festival in that copse. That's something that you can bear in mind when deciding whether you should be granting this or not. Just to end my submissions, I've included in my submissions a paragraph on hope and glory. You will have had it cited to you many times. What you're being asked to do involves an evaluative judgment as to what is to be regarded as reasonably acceptable in a particular location in which the interests of the wider community are paramount. And I've included extracts from the guidance, which repeatedly refers to the interests of the wider community. Of course, we understand that they want to raise a small amount of money for charity, but of course we understand that. Of course, we understand that they want to prove themselves to their father and make the farm work. We understand that. But if the cost in doing that is the cost to the wider community sitting behind me, then that is a cost which, quite frankly, is too high. Now, don't be tempted to say, well, we're granted just for 1 year. Please don't do that, because then we're going to have to come back next year and say, we told you this would happen, and it has happened. And we've had to go to the expense again of employing somebody to put our case on our behalf. The correct approach is to refuse it at this stage. This is the moment to say, I'm sorry, we've looked at our duties under the SDNPA. We've looked at what you've done before. We've looked at the way you put this application together. There's no question in our mind we have to refuse this. Come back when you've prepared a better application. And just think about this, just to throw this into the mix. If Boomtown is being held up as the prize festival in the South Downs Park, if you grant a second license, then that has an impact on Boomtown. Because when Boomtown comes up for its planning permission, which has to be looked at again next year, it's going to be looked at in the round with the grant of this license as well. And so the granting of this license imperils Boomtown and the levels that have been set for Boomtown. It's just something to think about. But we would suggest that the correct course in these circumstances is to refuse. Those are my submissions.
Thank you very much, Mr. Rankin. What else is the question about?
I think it's been perfectly clear.
Mr. Payne, do you have any questions of Mr. Rankin, please?
No, I have no questions. He'll be glad to know.
Thank you very much. The other people who have made representations, do you have any questions of Mr. Rankin? Thank you. Councillor Lamming has a question of Mr. Tittridge. If Mr. Tittridge could come to the table, please. Mr. Tittridge, would you introduce yourself, please?
I'm Phil Tidridge. I'm a chartered environmental health practitioner working for Winchester City Council.
Thank you. Good afternoon. We've got two conflicting reports on the sound.
So, sorry.
Yeah. And just to clarify things, if we've held up with Boomtown, but Boomtown doesn't have any residents as close to the site as this. Is that of fundamental importance to the way that sound is measured and whether we should be using a desktop or actual sound readings?
The noise levels would be set at the nearest sensitive receptors. So the only reason it makes a difference is if your nearest sensitive receptor to which that noise level applies, that will restrict the amount of noise you can obviously generate at source as sound drops at distance. So less distance, less sound at source. But the level that would be set at the receptor is the level that is set at the receptor irrespective.
Does that also take into account the vehicles of the catering companies and generators and all that?
No. Generally speaking, the noise level is set in terms of what we call music noise level.
Thank you.
That's it. Thank you very much, Mr. Titch.
Can I
No more.
just ask one very quick question? The question that Councillor Lamming asked you was whether Boomtown had residents as close as the application site. And the answer to that is what?
So I'll answer that if Councillor Lamming wishes me to answer that.
That is what he
Yes,
asked
as a
you.
point of clarity.
Boomtown does not, as far as I'm aware, have people as close as this site. So I understand why people close to the site would be concerned about this application.
Very much obliged. Thank you.
Thank you, Mr. Titch. That is good. Thank you.
Chairman, can Mr. Tidridge be released? Obviously, I'm mindful he's an environmental health officer. If he can go back to obviously his duties in the office, unless there's going to be any questions you anticipate going forwards.
Mr. Titch, you are released. Thank you very much for your attendance.
Thank you.
Councillor Ashwell has got questions for the applicant, please.
Chairman, if I may, it might be prudent at this point for obviously representations or submissions, if you like, because if we're at point 16 on your note, so the applicant premises license holder may address the subcommittee in order to clarify any points or issues raised by the representation. So perhaps first you might want to hear by way of any closing points being made by the applicant and then questions after that. Otherwise, we'll be questioning representations and perhaps more questions.
Over to you, Mr.
Yes, it becomes slightly circular otherwise. I will try and move this a bit closer. I'm grateful to your legal advisor. This application, as has been blatantly obvious, has attracted a fair degree of criticism. I say a fair degree, as in the degree has been fair. However, the criticism itself is not fair because it would be disingenuous to say that this is a poor application. This is not a poor application at all. This is actually a good application which addresses many of the points, if not all of the points, that one would expect to see on such an application. And you will notice mention has been made of Boomtown. You will notice the similarity of some of the conditions that have been offered, especially in relation to things like the event management plan with the Boomtown application, which has been granted. Now, what has been done with this application is the right process has been gone through and the applicant has spoken to environmental health and spoken to local residents before the application went in, and the application is as a result of those consultations. Now, we have a discrepancy between noise experts, And sometimes it's said that there are lies, damn lies, and statistics. One might say the same of acoustic reports, because each expert has a different view. The thing that I would put front and centre to you is that there is a party that has considered both sides of the argument, has assessed things in the round during the application process, and has come with a decision. That entity is your environmental health officer, who is your appointed expert. He is employed by the council. He is employed for his expertise, his ability to assess these types of events. And I'm sure that there is no suggestion that there is a question of competence in here. Quite clearly, he's competent. And the result of his assessment of the application in relation to noise is this is an application that can be granted, subject to certain noise conditions. That's the reality. Two opposing experts and one expert in the middle, who is the expert, and you'll appreciate this, is the expert in deciding whether there is a statutory nuisance, and as part of that, whether there's a public nuisance or there is likely to be. And his assessment in this is that there is no reason to make a representation on the basis of the conditions that have been fashioned together with the applicant. That's really important. It would be so wrong to say this is a poor application, because that would be suggesting that the council has offered poor advice and has agreed poor conditions. It has not. The same is true of the other elements of the application, the other elements of the event management plan. Now, you've heard criticism that the event management plan is going to contain this policy, that policy, the other policy. Now, again, what has been done with this application is that the policies that have been constructed, and I believe it's probably all of them by now, I'm looking to my right for confirmation, have been provided to the Safety Advisory Group. The Safety Advisory Group, consisting of the fire service, the police, environmental health, indeed your own licensing team, has looked at those proposals and again has not indicated that there are any issues that are of concern, that there are no changes that are needed to those plans. As a licensing committee, of course, we could provide you with all of the copies of those policies, but at the end of the day, your experts are there to help you and to advise you through making representations, which they've chosen not to do on this particular occasion. And that also is true of the South Downs National Park Authority. The submissions that have been made have been criticised in relation to what is the involvement of the South Downs Parks Authority, and I think what was actually meant to be the fifth licensing objective rather than the fourth, which was put to you, was whether the South Downs policies apply as a fifth licensing objective. Well, what I say is that they simply do not. They are things that you can consider, but they are not fundamental to the decision. Now, that is actually incorporated within your licensing policy, because the licensing policy talks about the South Downs Parks Authority as the planning authority. And of course, you'll be aware that the planning authority is an authority that receives a copy of the application and has the opportunity to comment. You've also heard that on this occasion, there has been no comment on that ground. Now, the new point of section 245 has been raised, and whether you have to consider the park authority's policies in what you say, in what you decide rather. I make the point that the Parks Authority is not in itself a responsible authority in relation to the environment. There is no fifth, I've made the mistake as well, licensing objective in relation to regard for the environment. That's not to say that the environment's not important. It absolutely is, and you've heard from my client in relation to their consideration of the environment and the importance that it forms within this particular festival. The reality is that none of the experts that are engaged to advise you have raised any objection to this license application. The only objection is from those living in the vicinity. Now, what we say is that this is quite clearly an application that is capable of being granted. Reference has been made to the Boomtown application on so many occasions, I've lost count of that. But it is in one respect something, I say, of a precedent to which you have to have regard. I'm conscious that conditions have been fashioned for that festival and for that event. And the conditions that you have now have in some respect a parallel to that festival. It would be entirely right to grant a similar license with the stringent conditions that there are offered for this particular application. Now, it may be that in order to meet, for example, the noise conditions, the levels at the stage will need to be lower. That's something for the applicant and hopefully the license holder to address. If they cannot play music as loud as they want to achieve the levels that are set and prescribed, that is a problem that they have to cope with. There are technologies, and you heard the phrase that there are technologies available to allow events to take place after 11 o'clock at night. And I think the example of silent discos was given. There are technologies available to make sure that the sound from sound systems on stages is projected in one direction and is adequately controlled. And councillors, you'll be familiar, no doubt, from dealing with other applications about those types of sound system. Frankly, it really doesn't matter what the level is at the stage. It is whether people are disturbed by the activities that are taking place. And my clients say that they can effectively run this event without causing disturbance. Now, if disturbance was caused, you granted a license, disturbance was caused, then of course there is, and you would expect me to say this, the process of review, and anyone can apply for a review of the license. So if the license was granted for this year, to I think take the point forward about let's have a trial period, before an event could happen next year, there is an opportunity for the license to be reviewed. One of the things my client is more than happy to do to demonstrate the point that we made earlier about wanting to talk to neighbours, which was evidenced through the pre-consultation meeting, is to have a condition on the licence that there will be a post-event meeting. My clients are very keen to do that, to discuss issues that are raised by local residents and to make sure that they are addressed. Now, my clients have said that in terms of the issues of the past, and you heard this from me earlier, there was but one interaction about problems having occurred. The first that they knew that there were any issues at all, other than that one interaction, has been through this license application. Clearly, a dialogue is really important here, and clearly a dialogue is important because this is something that is a slight change to the area. Holding an event in this location is something that has been done twice before, but it is a change. There is, of course, always a fear of change. And it is important that in order to manage that change, that there is a dialogue. That is what is hoped for, that is what is offered, and we hope that that is what is accepted. In terms of some of the representations that have been made, I know that some representatives have suggested that granting a licence here will set an uncontrolled spiral effectively into the future. That's not true at all. That's the furthest from the truth. There is control. You will have heard that in the past there have been temporary events notices put in place. If anything is uncontrolled, I would say that is the use of temporary events notices, because temporary events notices, with some exceptions, don't come with conditions. Now, it would be possible, I'm not suggesting that that's what's done, but it would be possible to run a lot of this event using temporary events notices. And we know that the police and environmental health don't object to that. What would be so much better, what would be so much more preferable, both for the applicants and for the locals in the area, is to have a license with strong, stringent conditions that must be met. Let's not forget that failing to comply with conditions on the license is a very serious matter indeed. So it is beholden upon the license holder to make sure that they comply with those stringent conditions that have been offered. I've already suggested that the question of a further condition and the requirement to meet with local residents, as I say, my clients will be willing to do that and to have that fixed in as a requirement and a condition of the license. There have been mistakes from the past, but they have learned from those mistakes, and that is the important change. You can see that they have brought in professionals to deal with this license application. They've brought in professionals to manage the site, which is even more important, to make sure that there is noise control, that there will be monitoring going on, that there is a community line so that if anybody is disturbed, they can contact the festival straight away. The festival can act on that. And the assurance is that they will indeed do so. With all that in mind, with the assessment that has already been conducted by your experts in this matter, and without wishing to burden you with some of the technical detail which I said would come and quite clearly did, licensing committees are not expected to be an expert on everything, and that's why experts are appointed, and that's why we have responsible authorities. With all that in mind, what we say is this is quite clearly a situation where a license should be granted. Whether it's kept is a matter for the license holder and making sure that the license conditions are met. You as a licensing committee have the power to impose those conditions and indeed more stringent conditions if you feel that that is appropriate. And so with that, I commend the application to you and say, would you please grant this application to allow this business to continue, to allow others to come into the area to appreciate what is there and to help this business going forward. Thank you.
Thank you very much, sir.
Thank you.
Yeah. Councillor Ashwell.
We'll go, quite a few questions I have for the applicant. Can you hear me? Yeah. Some clarifications, and some questions. If I look at your page 6 of the application, it says the application is for more than 5 consecutive days. And as I understand, in your application, you're talking about Thursday, Friday, Saturday, and Sunday. That's 4 days. Why are you looking for 5 days? This is on page 6 of your main on agenda item 1.
I'm sorry, which page of the actual?
Page 6.
Page 6.
Chairman, I think probably in the agenda pack, it's the actual application form you're referring to,
Yes.
Councillor. Yeah, that's not page 6. Much larger, page 25.
Okay, I'm looking at my electronic copy of it.
This is section 1 of 21.
Part 1.
Is that form?
Yeah.
Yeah. Sorry, I'm struggling to find the reference.
That's the application I'm looking at. That's the statement. So part 1 application, section 1.3.
The officer's report.
Okay, so it's for the officers to page 6.
I know there's a
Councillor's looking at the officer's report. So between the parties, we're on page 6. The council was looking at the officer's report, paragraph 1.3.
Okay.
Yes, 5 consecutive days each calendar year. So the reason for putting 5 calendar days was to allow some flexibility, given that this is a permanent license. That's not to say that it would happen on every 5 days. Indeed, my instructions are that music would only actually be played on 2 of those days.
According to your application, it says Thursday, Friday, Saturday, and Sunday.
Yeah.
Music will be played. So either you play all the 4 days or stay only 2 days and make it clear that that's how it will happen. It's not
Yes, I
clear to
can
me.
understand the ambiguity in it, yes.
I don't know how will you correct it, but that needs to be addressed.
Could I just take instructions on this? Just one moment, if I could. Asking how about that? How many?
4 days.
Oh, yeah.
They say 5 days.
So that's the officer, saying that though.
No, but they've said it
Oh,
in the application.
Right.
What's it?
Before, and for no one.
okay. So for the purposes of the committee, one of the conditions being put forwards, page 49. Condition A4.
Yes, that was the 5 days. Sorry, I'm just taking instructions on the number of days that they actually want to play music, which was to do with the question.
And then on page 32 is the application. Live music. Thursday, Friday, Saturday, Sunday. Page 32.
Yeah.
So there's a degree of conflict with the as applied for on page 32 and A4 condition.
Right. Having just taken some instructions on this, just so that there is clarity, the request that you have, irrespective of what's put on the papers at the moment, is that there are 3 consecutive days when music would be played. That is the request. That I know that there are reference to 4 days and there's reference to 5 days, but just to be clear, there will be only 3 days when music would be played. If you want to take that as an amendment to the application effectively, then we're content to do that.
On page 32, it states Thursday until 10 o'clock, Friday until 2 a.m., Saturday until 2 a.m.,
Yes.
Sunday until 11 p.m. So which day is not going to have music playing?
Is it the same with music? Yeah. Councillors, again, the same question for the provision of alcohol. You'll see it reflects the provision of recorded music. So the same question carries across. Maybe we should adjourn for 10 minutes here. So instructions.
I think that would be very helpful. There's
the
a
applicant does
discussion
need to be
going on
clear.
here, as you can see, which is essentially, I think, the long and the short of it is to suggest that we're happy to modify the application to make it clearer, because is this slight dilemma about 5 days or 4 days, or what is it? If we could have literally 5 minutes, we will come back to you and tell you which days of the week that would be, which I know is the question, and therefore how many of those there are.
For both music and alcohol?
Yes, indeed.
For all licensable
All
activities.
licensing.
For all licensable activities, exactly.
Okay, yes.
I'm
Okay.
grateful, thank you.
Yes, in that case, I adjourn for 10 minutes.
Chairman, you did say 10 past, so in the interest of justice, for those other persons who have put representations in, who are not here, I'm afraid there's going to be 5 minutes of silence.
Meeting is reconvened. Mr. Payne.
Chairman, I'm really grateful. I can understand why there is some confusion, and it really revolves around A, the question of flexibility, and then B, when a day starts and ends. Now, I have a particular way of completing these forms. I didn't complete this one, but what is sought, just to be absolutely clear, is licensable activities would commence on a Friday at 12 o'clock midday, and they would go through until 2 o'clock on Saturday morning. On Saturday, from 12 o'clock until 2 o'clock Sunday morning. and then licensable activities would cease. So on the application form you've got, the way of dealing with that would be to cross through Thursday, because there's no wish to do licensable activities on a Thursday. And then on a Sunday, the only licensable hours, and this is the point that I make about when does the day start and finish, licensable activities would be from midnight through to 2 o'clock, because that's Saturday into Sunday, if you follow me in that way. So effectively, strictly speaking, there are 3 days when there will be music played and other licensable activities carried out, but it's because it runs from one day into the next. I hope that's clear.
So Sunday from 12 noon to 11 p.m. is
You
scrapped.
can strike that through. Yes, absolutely. The way that I would normally do these forms is on the Sunday, I would put that licensable activity starts at midnight because it's following on from the previous day and finishes at 2 o'clock, because that is actually on that day, even though most people think of it as part of the night of the day before. It's confusing, isn't it?
Okay, that's fine. Yes, we got another question for the solicitor.
Yes, I do.
Yeah.
So, page 11 in front of me. I don't know which, let me pull out the page from the license a second. Page, observation page. Don't know whether you have it there.
This is the agenda one.
Yeah, the licensing objectives, we're talking about page 11 of mine. I don't know which one you're talking.
Is this the officer's report?
Officer's report? Okay. So a question on public nuisance and public safety. Now, we heard a lot about public nuisance in terms of noise. Now, if I look at your report, F1 acoustics reports on page 14, table 1. This is the agenda item number 1. So 2 things I want to point out is table 1 talks about the guidelines given for the noise levels depending upon the number of days of the concerts are. So between 4 to 12 days, which I was going by, the MNL should not exceed the background noise level by more than 15 dBA over a 15-minute period. That's the guideline. And if it was less than 4, then of course the MNL should be 65 dBA. But now we are talking about the 2-day period, so we're talking about 65 dBA over the 15-minute period. That's one thing to keep in mind. So when I saw the report is based upon some base noise levels. I think you all talked about pop. I think that's the word that you used. If I can get to that page. Yeah, page number 31. It talks about the source input music noise level frequency spectrums from 63 hertz to 8 kilohertz. There are various levels that I'm talking about. Now, I understand that's the standard used for noise study. So I wonder whether you have taken into account the source of noise at 2 places simultaneously, 2 stages you got. So if you are playing the same source, same kind of noise source from 2 sources simultaneously, the results that are tabulated out there, do they reflect this particular condition?
Well, let me deal with that, because I think I'm right on my instructions that there is actually only 1 stage. Now, I know on the plan there is something marked secret stage or something of that nature. That's not actually a stage on my instructions. Am I right? Right.
Stage, not
So It's not a stage yet.
1 till 11, 1 later.
Right.
So
You're talking about your original application,
Yes,
which says 2 stages.
yes,
And
correct.
that are clearly marked over here. And if you are playing music on both stages, does the noise study that is reported here reflect the sound coming from the 2 stages simultaneously? That's the question.
after 11.
Yes, this on page 31 that you've got is just based off the Woodland stage, which is the only stage that would be operating after 11 o'clock. That's what that reference is to. The Woodland stage is the one that operates after 11 o'clock. Those are the levels for that stage.
Not clear in the report anywhere, so I have to understand what you're saying.
No, indeed, that's just the instructions I've just been given. That's the situation. These figures on this page are for the Woodland stage, which is mentioned, and that's the only one that will be operating after 11 o'clock at night.
How many will operate prior to 11 PM?
So there'll be 2 stages in total before 11 o'clock at night.
2 stages before.
So even before 11 o'clock, the 2 stages are working, let's say. Does the result, the table, does it reflect that? That's still the question.
So that particular table just refers to the one stage.
Yeah.
What has been considered as far as the other stage is concerned is the overall noise level, noise limit that has been agreed with environmental health. They said imposed, but agreed with environmental health. So the overall noise level that has been agreed is the one that takes account of both stages.
I'm a bit skeptical about that because I would like to see the simulation done for the 2 stages and the noise coming out from 2 stages and see how the noise, the levels of noise are at this sound level.
The interaction between them.
I'd like to see
Yes,
that.
that's something we've not been asked for before. It's certainly something that you could, if you wished, add a condition on that has to be shown to the environmental health officer and or the licensing authority, or both. Well, it is both, in fact. You'd want to do that. So there's no difficulty in doing that. It's just that hasn't been part of the brief today. That's the first we've heard.
My concern is because this being a rural area, at night the noise levels are no more than about 30 dBA, and that's already somebody proved that as well. With that in mind, if you're looking at the noise levels we're talking about, I'm very concerned of the level of noise that will be heard in the neighborhood, not just the close 100, 200 meters away, but about a few kilometers away in Bramdean, for example. That's my observation.
Well, absolutely understandable that is a concern, and that is why the conditions have been structured the way that they have and agreed that the way they have, that noise levels are set and monitoring locations, wherever that may be, whether that's 100 meters away, 200 meters away, 2 miles away, are agreed with environmental health in advance, and those levels must be met at those agreed positions. So the flexibility of the condition is the beauty of it, that actually environmental health can agree new monitoring locations year on year, if that's appropriate. Now, sometimes it is a case that a monitoring position is chosen, but actually on the day it's decided or it's found out that actually that's not appropriate, and in a future year that needs to be changed. The ability of the conditions to be flexible has been built in, and that's one of the good things about this application. So you're concerned about where the monitoring points are, it's taken care of.
My concern is it should not be fait accompli as a part of condition, because it might turn out your sound levels are much higher than expected, but then you can't do anything about it because it has been agreed. So.
Well, indeed. So that's why the condition is phrased as it is, so that the agreement can be changed. And that's really important. That takes your point front and centre, and make sure that in future years, or indeed on a second day, for example, if the monitoring on the first day was found to be or the location was found to be inappropriate, that could be changed for the second day. So that's the flexibility that's been built in, and I'm sure that my clients would certainly want to work with environmental health to make sure that the locations are appropriate because at the end of the day, they don't want to be served with a notice. They don't want to disturb locals, and so they will work with environmental health, as they've shown they have done already.
Thank you.
My colleague said that based on 2 nights activity now, the minimum noise level should not exceed 65 decibels over 50-minute period above the background noise level. Correct?
Yes, and of course the background noise level is that level at that time of night. So that would require background levels to be monitored as well.
Well, we know the weather conditions, wind direction, cloud cover, humidity, etc., can in layman's terms impact greatly on the intensity and the travel of noise, especially in open countryside at night. Can you therefore point me in the direction of your background noise measurements already? The increase in decibels caused by the music from the 2 stages combined above these background levels, and the impact that this has on the Krishnamurti Foundation and Brookwood School.
Yes, so my instructions are that background levels have been taken, but they're not part of the report. I believe that they've been provided to the Safety Advisory Group.
Point is, all of this was right submitted. I think whilst I'm not the noise management person, the noise management person did work in conjunction with your EHO team to give us these conditions, and now we seem to be almost going around in circles about the conditions again. So what was put onto the license application was what was requested by EHO.
Yeah,
But surely your acoustic expert would have known that background levels should have been taken in the first instance.
yes, and I understand that they were taken. Now, the point that you make about environmental conditions changing is fundamentally important. And that's why, in terms of this sound level criteria that you've mentioned, it's important to have background levels on that day when the event is happening. That can be done. So the condition would essentially require a background level at the time of the event so that all of the local variations and the weather conditions can be taken into account on that very day, which is the day that the measurement's being carried out. What's been done before is helpful in terms of scoping and trying to assess whether it's possible to achieve compliance, and our noise consultant says yes, and that is agreed with environmental health. But on the actual day, it's really important, and that's what's proposed, to make sure that measurements are taken on that day. That's the fundamental point. On that day, are people disturbed? In order to work that out, we need to look at the background levels on that day. Those levels will be taken.
The base level should not be on the day. The base level should be established up at least a week, 2 weeks before the event, because that's the where we're starting from. If you're doing the base level on the day, you already are muddying the water.
Well, what needs to be done is that a background level needs to be taken when there's no licensable activity taking place quite clearly to get that. Sometimes actually a week in advance is too early. Sometimes these noise measurements are taken on the day before the activities start. Sometimes they're done the day before. If you want to fashion a condition that background levels must be taken a particular period in time in advance, I'm sure that would be acceptable.
Forgive me to butt in, but I think the 30 decibel dBA is a kind of standard for the UK conditions in terms of normal base level at night. So you can take it for granted that you will not be very far away from that. So that would be the basis, and then you can work out on that basis what is the noise level your guidelines tells us, whether it's 15 dBA more or 65 dBA. That would be my approach rather than.
I agree as a starting point, but as a starting point, that is a good basis to work from.
We are not here to do technical discussion for sure. So we need to go further on that noise level.
Yeah.
Any further to talk about a noise level? I've said enough, and I'm not too happy about what we got here.
Councillor Lamming has a question.
Yes, when we're looking at the build-up, how many days build-up have we got allowed for in this?
Yeah, the whole process of build, so as they sometimes say, first peg in would be 3 to 4 days. So
Right, so
the-
you're going to need power on site for those 4
not
days.
not necessarily, no.
But what level of generation are you going to put in there? Because that will affect the background noise in the first place. So therefore, we need the background noise to be taken a week or so in advance. Otherwise, we've got no baseline to work from.
Yeah,
And
absolutely.
this is a particularly sensitive area,
Yeah.
and you've got sensitive neighbours, and we're very conscious of that.
I agree that the background shouldn't include things like generators. That's not part of the background. That's not part of the normal background. So yes, those would have to be excluded from the measurement.
So how are you going to bring in the catering trucks and all that?
Well, they wouldn't be coming in 2 or 3 days in advance.
No, but you're going to get the main build coming in. So therefore, which access point are you using to come into the site?
To be honest, that the access point would be we're coming down from the A272, isn't it? Yeah, and up towards the site. It wouldn't be via the road that goes towards the school. It would be from the other direction. So
Can I just say something in relation to that? Because we've not given permission for that road to be used. And that
Yeah.
permission will not be forthcoming.
Yes, can you respond to that question about the school's permission, denying you permission to use it for the use of the emergency vehicles?
That's obviously something that we need to discuss with the school. I can hear what's being said about permission not being granted. Frankly, if the proposal is to do that and there is no access and there's no possibility of amending things, there is no event, is there? That's the fundamental point about it. But that doesn't affect whether a license should or should not be granted. Essentially, the license can only be granted or can only be used if those access routes that have been planned are available.
Thank you very much. Thank you. Anybody got any other questions or points to make? Ah,
Yeah.
so,
I have some questions about the traffic. I see on your map, again on page 23, even though it's used for acoustics, I'm not too sure about the geography of that area. What I see from the map is on the left-hand side bottom is the access, is a gate to the event. Am I right in saying that? Page number 23. Yeah. So left-hand side bottom is the access. Now I'm not too sure what's the method by which the traffic will end up in that area. Or I don't know. When I looked at the OS map, there doesn't seem to be any traffic or any road, a road which can be taken into that. Maybe it's my ignorance completely, but you need to show me that.
So there is a road up towards the other end of that field. Obviously, it is the middle of summer. We would expect the field to be dry. If not, then we might need trackway or something similar. But there is the ability for vehicles to drive across that field. So
From the gatehouse.
yeah, no, not from the gatehouse, from the other end. What's that for?
There's a road up, it's included in the traffic management plan, there's a road up from the 272.
Yeah,
A private road, which is hardcore from 272.
it's a track.
Yeah, hardcore track up the hill, and then we can go across and park just outside the gate that you're referring to there, and then people will be walking into the site from there.
And
It's
in
private
case
access.
if you have a private vehicle, taxis and all that would come through, will they come through that particular road?
Yes, up that road as well. It's designed for cars.
Okay. Well, I wouldn't be driving there. Yeah. I just wondered, because it's not on the OS map, that's why I just wondered whether there's a road there or not. And if there's a road, and if you're saying it's a road, brilliant, okay. I wasn't aware of it, so that's the only exit and the entry point. Am I right in saying that? So for the emergency vehicles and all that, that will be the only way they can get to it. Okay, thank you.
With regard to the traffic management plan and access for traffic coming in and out of the site, how is that going to be controlled and who's going to control it?
So we've engaged with a company called Last Mile, who work across many events. They were the authors of the traffic management plan in an early status, and it would be controlled by both personnel, signage, and then when it was delivered to the safety advisory group, the highways had no comment and thought it was fine, and there was no problem with them.
Thank you.
Is that everything, councillors, in terms of questions for? I think at this stage it might be wise for parties, and I'm also mindful for press here, as to what is actually being applied for. I think we should go through page 29 and the operating schedule and the licensable activities. I hear what Mr. Payne said, but if we go through the actual application form, it might be the best approach here. I'm just conscious that members, we've obviously got to make a decision now on that revised application. So at page 29 is the operating schedule in the main agenda pack. Section 7, provision of films. Thursday, Mr. Payne, your client's instruction.
So Thursday would not apply.
So no provision of films will not apply.
No.
Friday?
Friday would be 1400 till midnight.
Okay, that's just different to what your submission was. It was midday to 2 a.m.
Yes, indeed. We put 14. That's a lower period, so that's what we've applied for. That's what we would ask for. Sorry, I hadn't realised that was 1400 rather than
That's why
midday.
I'm going through it.
That's a very sensible approach. So 1400 to midnight, and you'll see that that's actually finishing earlier than we also mentioned earlier.
Okay, so that's fine.
Similarly, on Saturday, I think the 14th.
Yep. Okay. Sunday?
But Sunday, there would be nothing.
Okay, so we strike Sunday for page 31, provision of films.
And then you have live music.
Live music starts at page 31 over to page 32.
Strike Thursday.
Strike Thursday.
And then strike Sunday 12 till 2300.
Sunday 12 till 2300. Leaving, as you rightly say, midday till 0200 for both Friday and Saturday.
Yes, indeed.
Okay, thank you. Page 33 now, provision of recorded music.
So that would replicate, oh no, we've got, Thursday would be struck. Again, the Friday would be the same as per live music.
Indeed.
Saturday would be the same as per live music. And so with Sunday, I struck through.
Sunday struck. No performances of dance.
No.
Provision of anything similar description to live music. There is something, page 35.
Yes. So strike Thursday.
Thank you.
Friday 12 till 0200 Saturday. Saturday 12 o'clock midday till 0200 Sunday. Strike 12 on Sunday till 2300.
Okay, thank you. Late night refreshment, page 36.
So that would be 2300. Sorry, 2300 till midnight would be struck
For Thursday.
for Thursday. Friday.
Going till 4. This is the conflict. This is obviously why I put it to you.
I feel quite right to do so. Yes. Okay, agreed that should be in line. So 2300, which is when late night refreshments start, of course. before 2300, one doesn't need a license.
Indeed.
So to conclude, 0200 on Saturday,
Friday, did we say?
on Friday, yes.
Sorry.
And then similarly on Saturday, commencing at 2300 on Saturday, concluding on 0200 on Sunday.
Okay. Supply of alcohol, page 37 over to page 38.
Yep. So we strike Thursday. And we strike the entry that currently applies or appears on Sunday.
Much obliged. Yes. And finally, one which hasn't been raised, which I think rightly should be, hours of when it's open to the public. Page 40, if you can take instructions.
Yes, in the interest of traffic management, we ask that remains as it is on the application form. Of course, it's a matter for the licensing committee what hours they wish to grant.
The members, you hear that, that is to remain unaltered for when the site is open to the public.
2 o'clock on Thursday.
Before members retire, there's also a point of clarification indeed, which I probably will need parties to assist me with and the committee. Page 49 is the start of, if the committee is minded to, of course, grant the license. We have the condition A1. The premises license holder shall notify the licensing authority of any licensable activity proposed to take place under this premises license in writing, and no less than 6 months in advance of those licensable activities. So of course, if the members are minded to grant this, this is setting you up to fail, because obviously you shall not be in time. So between you, if you could come up with some suitable words as to how you wish that to read.
I think that the licensing authority have been notified already. However, there is perhaps a clue to that, because I think on the following page at A6, under the EMP deadline, it talks about the deadline for submission of the EMP may be altered in writing by the local authority head of licensing following a written request from the premises license holder. That similar wording perhaps could be used in relation to the condition you mentioned.
Chairman, it's a matter for you. Obviously, with respect, that's referring to the event management plan, which is different to obviously notifying when proposed licensable activities will take place under this premises license. Appreciate, obviously, we've been notified, but it's currently in relation to an application.
No, you're absolutely
not
right.
to the premises license. So
suggesting amending that condition.
Something that we could come up with.
To include A1
Sure.
notification as
So
well.
maybe something along the lines of notwithstanding any event held in 2024, the premises license holder.
Indeed. Indeed.
Okay. Mr. Rankin, do you have anything to say on that point? Obviously, that condition is perhaps arguably setting up the applicant to fail. It's just reaching a reasonable compromise here on that.
It's a matter for them. I have no input on that condition.
Much obliged. Thank you. Also, Chairman, just so we're all on the same page, much has been made about section 245 of the Levelling Up Regeneration Act. Just so I provide this in open session, it's a point of law, so it's right that we take this away. 245 of the Levelling Up and Regeneration Act relates to obviously the duty in regards to the national park, and in this case, the South Downs National Park. The officer report at page 6. If the parties could perhaps look at page 6, please. Paragraph 1.6 refers to, as set out in section 11A, subsection 2. In that regards, we turn to section 11A, subsection 2 of the National Parks and Access to the Countryside Act 1949. Members, if you're minded to, and obviously with parties present and their legal advisors, that section actually subsection actually relates to Wales. So looking at the National Parks and Access to Countryside Act 1949, in exercising or performing any functions in relation to or so as to affect land in a national park in Wales, it's an error in the officer's report. I think what it should say is 11A subsection 1A. So if members can.
Correct.
So members, if you're happy with that amendment, obviously this could lead to points of appeal if depending on where we go. So if parties are agreed, the officer's report should be amended to reflect that. So 11A subsection 1A, 1 capital A, 245 has been mentioned about the Levelling Up Regeneration Act. All that does is actually amend this act, the 1949 Act. So your duty is actually engaged in relation to the amended 1949 Act. And with that corrected duty, 11A 1A, which reads, in exercising or performing any functions in relation to, or so as to affect land in any national park in England, a relevant authority other than a devolved Welsh authority must seek to further the purposes specified in section 5.1, and if it appears that there is a conflict between those purposes, must attach greater weight to the purposes of conserving and enhancing the natural beauty, wildlife and cultural heritage of the area comprised in the national park. I think that's where we are, just obviously so the correction can be made. The actual duty is 11A 1A, as has been amended by LURA, as we know in the trade, Levelling Up Regeneration Act.
Mr. Lucas is spot on.
With that, members, it's a matter for you now if there's any more questions, if you wish to retire.
Right, thank you very much indeed, everybody. Ladies and gentlemen, the subcommittee will now retire to consider its verdict on this matter. Thank you
For
very
the
much.
purposes of the gallery, we shall retire. There's less of us, so we have a room set aside so everyone can take.
Chairman, could I just ask, is it your intention to return with a decision today, or are you going to notify that within 5 working days? Very good.
That gives chairman to draft a decision by close of business at 5 PM. It's possible.
It's possible, but
I was just conscious of essentially the hour of the day and whether actually it is perfectly acceptable to send the decision through rather than requiring everybody to remain. While
it
you
could
make the
easily
decision.
be that way, if you know what I mean.
Yes,
Because of the amount of stuff we've got to go through.
yes.
How about if we get to 4:30 and members are no further along in their deliberations, we come back and give an intimation that probably a written decision. So it's only 3/4 of an hour to wait. So 4:30, we should be in a position to say whether or not
Yes.
we can give an ex-tempore or
Do
written.
you live with that? Okay, fine, done.
I'll pause the recording for the time being.
This meeting of the Licensing Committee is now reconvened. Application for new premises license, Brockwood Festival, Sheep Dip, Hinton Apner, Alresford, Hampshire. SO 24 0LF LR 585. In reaching its decision, the subcommittee has carefully considered the amended application as presented today and the applicant's and other persons' evidence. It has taken into account the Council's statement of licensing policy, particularly those sections which relate to the South Downs National Park, the public sector equality duty, the Home Office guidance issued under Section 182 of the Licensing Act 2003, the duties under the Crime and Disorder Act 1998, and the rights set out in the Human Rights Act 1998. In exercising its function, the subcommittee also duly considered and assessed the application against a duty specified in Section 11A(1)(a) of the National Parks and Access to the Countryside Act 1949 as amended. The subcommittee has concluded that the application should be refused for the following reasons. The subcommittee considered that the weight of evidence against the application in relation to the prevention of public nuisance objective was compelling. In particular, the report submitted by Sustainable Acoustics on behalf of the Krishnamurti Foundation provided a persuasive assessment of the tranquil and exceptional characteristics of the background noise conditions for this site and the resultant impact the grant of a premises license, as applied for, would have. The committee could not foresee any conditions relating to noise and its impact which would overcome or mitigate against this objection, taking into account the site's exceptional characteristics. In particular, the evidence suggests that there is, on balance of probabilities, a real risk towards interfering with the ordinary use of the land as a retreat and for those who use their overnight accommodation. In forming this conclusion, the subcommittee had particular regard to the statement of licensing policy and the duty contained in Section 11A(1)(a) of the National Parks and Access to the Countryside Act 1949 as amended. Despite the South Downs National Park not objecting, the licensing subcommittee must still have regard to this duty. Consequently, the evidence submitted by the other persons, and particularly that of the Krishnamurti Foundation, illustrates a very real risk of creating a public nuisance to those within the vicinity of the proposed festival, and therefore does not meet the requirements of promoting a singular licensing objective relating to the prevention of public or nuisance, and the duty relating to conserving and enhancing the natural beauty, wildlife, and cultural heritage of the area, as expressed in the Council Statement of Licensing Policy and Law. The parties will formally be notified of the decision in writing shortly. This notification will include details of the right of appeal against this decision to the Magistrates' Court, which must be made within 21 days of this notification. Thank you for your attendance. That concludes the business of the subcommittee.